So what happens if the police violate your constitutional rights in collecting evidence against you? Well, today it's excluded. They can't use it in a court of law against you. However, that hasn't always been the case. Find out more in today's episode. I am Joshua Roberts, attorney at law, and you are watching Lawyer Up. Today we continue the series on epic Supreme Court cases. In this episode, we're going to look at the case of Weeks versus the United States. And what makes this case epic is that it set up the exclusionary rule that says if the government violates your constitutional rights when they're collecting evidence or investigating a crime, then they can't use it against you in a court of law. We're going to look at the parties involved in this case. We're going to look at the facts. We're going to look at the decision of the Supreme Court. We're going to look at their reasoning. And then I'm going to tell you why this case is epic. If you like the episode, then hit that like button. If you got something to say, comment below. If you enjoy information of a legal nature, then subscribe to the channel. And as always, I love it when you share me on social media. So when we're talking about the case of Weeks versus the United States, this case was decided by the U.S. Supreme Court in 1914. And the parties are a man by the name of Fremont Weeks. He lived in the state of Missouri. And of course, the defendant is the United States, which would be the United States government that was prosecuting him. Now, the facts of the case were as follows. Mr. Fremont Weeks was involved in illegal gambling activity. And, he pretty much was. So what the government did, they knew he was doing some things that were illegal. But instead of getting a search warrant, they found a neighbor who had a key to Mr. Weeks' front door, and they just helped themselves. On two separate occasions, they used a key to just go inside of the Weeks residence to collect papers and information that had evidence of illegal gambling operations, and they took that information from the home. Now, later on at the trial against Mr. Weeks, this information was used, and he was convicted of illegal gambling. After his conviction, Mr. Weeks appealed up to the Supreme Court, and the Supreme Court said, yeah, no, you can't do it that way. They said you need a warrant to search somebody's home. And specifically, they relied on the Fourth Amendment. And I'm going to read that to you. The Fourth Amendment says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So in the Weeks case, the police probably had probable cause of illegal activities. But they don't get to just unilaterally decide. Law enforcement has to articulate the probable cause under oath and apply for a search warrant specific to the place to be searched. And that application has to be signed off on and approved by a judge. In this case, that didn't happen. And so the Supreme Court established the exclusionary rule, which says that evidence obtained in violation of constitutional rights is excluded from being admitted at trial. Now, obviously, this was a big deal. However, it was limited to federal courts at the time. Now, in 1961, the Supreme Court affirmed this decision in Mapp versus Ohio, which extended this exclusionary rule to state courts as well. So the same rule applies in state courts that applies in federal courts. And interestingly, Weeks and its progeny, or its other cases that are built upon Weeks, have established what's called the fruit of the poisonous tree doctrine. And that says that if the original information that was obtained in violation of a person's rights, then any fruits of that poisonous tree or that illegally obtained information is also prohibited. And let me give you an example of that, looking at the facts from the Weeks case. Now, we know that law enforcement obtained information of illegal gambling from Mr. Weeks's residence. And presumably that was correspondence between people who were illegally gambling with him. So even though they couldn't use that information against Mr. Weeks because it was illegally obtained from his home, they could kind of reverse engineer information because in that data they had all of his customers. So in theory, they could go to the judge and they could say, well, give us a search warrant to search these customers' residences, right? And then they could get information from there and kind of reverse engineer a case against Mr. Weeks. But subsequent cases have said that you can't do that. The original information is barred and any fruit from that original information is also barred. Once you do something bad once, anything that stems from it is also tainted and can't be used in a court of law. What makes this case epic is A, it protects the rights of Americans in the United States, and B, it spawned the motion to suppress practice in criminal cases. And these are the most commonly significant motions that are filed by criminal defense attorneys, is to suppress evidence, to have evidence excluded from trial because that evidence was obtained illegally and in violation of the client's constitutional rights. So that's the episode on Weeks, the exclusionary rule, and why that particular case is an epic Supreme Court case. If you have enjoyed the episode, hit that like button. If you got something to say or a comment, put it in the comment section below. Subscribe if you haven't yet. And as always, I love it when you share me on social media. My name is Joshua Roberts, attorney at law, and you've been watching Lawyer Up.
Send lawyers, guns, and money.